we have a very dear friend of ours who has come and presented to us before, and we wanted to bring her back because we know all of our worlds have changed a little bit after COVID. So we need to talk about how do we navigate through the aging process successfully. And that involves some legal and financial issues that are always very confusing for all of us. So we asked Virginia Sampson, who is one of the best lawyers that I know, to come and talk to us today about all those aspects of things that we know we need to do, but we're not really sure where to start. So Virginia's going to do a presentation. We'll do Q&A afterwards, and then we will stay here for our second presentation at 11 o'clock. But it's my pleasure to bring to the stage Miss Virginia Sampson.
Morning, everyone. So my goal here is to hopefully reduce your stress, right? That's my goal here today, and that's my goal as an attorney, is to reduce your stress. And like with anything in life, we need to plan. Those of us that plan, and I'm not always the best planner, I have to admit, but those of us that plan have less stress when an event occurs, right? Whether you're planning for retirement, you're planning for your kids' college education, having some kind of a plan and being prepared makes a huge difference when the event actually occurs. And that really is not any different with the aging process, right? Or with illness that can strike us at any age. So I have been an attorney for many, many years, and I began to focus my practice more on elder law, estate planning, probate, primarily as a result of helping my parents and my husband. I was a full-time caregiver to my husband for 3 years. He passed away from ALS. And then my parents moved here to live near me from Pennsylvania when my mom's health started to decline. So I was her caregiver. She had a stroke, she had dementia. So I understand if you're a caregiver, is a lot of what you are going through. It's very stressful. It's one of the most important and one of the most difficult jobs in the world, and in one in which you don't always get a lot of support, including from family members. So I hope today will help ease your mind as at least to the legal aspects of what you need to do to be prepared for illness or aging for yourself and for your loved ones. All right, so we can start with our PowerPoint. I'll talk a little bit about attorneys, because hopefully after this you will want to contact an attorney to get a plan in place, and you may be confused as to what type of attorney you need, right? So there's elder law attorneys. Elder law attorneys primarily deal with issues while you are alive, right? What documents do you need in place to manage someone's affairs, health-wise, financial, while they're alive, or who do you want to appoint to manage your affairs while you're alive? That's primarily also elder attorneys do Medicaid planning. And, you know, how do you pay for long-term care? That's one thing we'll discuss this morning. There's only a couple of government programs I'm aware of. One of them is Medicaid, and one of them is certain VA benefits that are available. So when you get into estate planning, that's when you have a lawyer who's going to prepare some documents for you after you pass. Now, sometimes they'll prepare the other documents as well, but that's usually wills, trusts, what's going to happen to your property after you're deceased, where do you want it to go, how do you want that to be handled. That's primarily estate planning, and remember, these spill over into each other. And then we have probate. A lot of people don't understand what the probate process is. It's a little outside the scope of what we're talking about today, but probate is the process by which, if there's a will, somebody applies to the court to have the will determined to be valid, right? I mean, just because it's a will signed and you have the original does not necessarily mean it was not revoked, or that's the only will of it out there. The court determines that it's a valid will. They appoint an executor who then gathers up all the assets, right, and pays all the debts, and then disperses the assets to the beneficiaries. So that's the probate process. You can, if you don't have a will, that's what we call an Airship Administration, where this court determines who the heirs are based on the laws of the state of Texas, and then you go through the other steps. So I have people come to me all the time. Maybe they want to do a Ladybird deed, or they want to sell their house, but guess what? They never took their deceased spouse's name off the deed. So you don't automatically inherit the house when your spouse or your co-owner of the property passes away. So you do need to take some legal action. Maybe not necessarily a probate, but you're going to need to do something. So those are the types of lawyers that, just keep in mind as we go through our PowerPoint. I'm going to talk primarily about elder law today. So what documents do you need as a caregiver or for yourself to enable someone to manage your affairs if you become incapacitated, either permanently or even temporarily? People just cannot step in without certain documents and manage your affairs. Okay, so my clicker. Am I doing something wrong? Oh, there we are. Okay, and remember, this is just for purposes of information. Everybody's situation is different, and so if you are interested, I would encourage you to find an attorney and get advice specific for your situation. Right? Everything, you may not need every document here. You may have certain things that you need that aren't in this presentation. So I would just recommend that this isn't specifically legal advice. This is for informational educational purposes only. All right. Oh, thank you. Okay. All right. So I get this a lot. People will say to me, gosh, we're healthy now. I don't think there's any real rush to take any action, to do any planning. Well, as we know, our health is fragile, right? Especially as we age. And I have clients who are healthy one day and then the next day they're in the hospital. So I would say to you, even if your parents or your spouse or whoever in your life that you're caring for, or you feel healthy, it's good to have this plan in place. I mean, I have people as young as 30 that do this. It's not something just for us as we get older. Okay, so a lot of us think because we're the primary caregiver or we're the spouse that we're automatically going to be able to make healthcare decisions for our husband, our wife, our partner, or our parent. That's not true. There is a statute on this in the state of Texas, so the state does designate who can make healthcare decisions for you if you don't have a written document designating someone. But if it's typically your spouse, and then after that it gets a little bit murky. So if something happens to you or you don't happen to have a partner or a spouse, it can get a little bit disconcerting. And as we know, everybody responds to stress differently. So if you have several children, that can result in some kind of stress or some kind of conflict among them as to how to handle your health care. Okay. So we're going to talk a little bit about, so also you cannot make financial decisions for your spouse or a loved one automatically. Now, if you are a joint owner, say on a bank account, of course, you both co-own it. But if you own any kind of real property, you're not going to be selling that property or doing anything with that property if your spouse is incapacitated or the co-owner is incapacitated, unless you have a specific legal document designating the person who can manage that for you. And then, everybody thinks, I get calls all the time, oh, I don't think I'll qualify for veterans benefits or Medicaid because I'm not totally broke, right? That's a myth. You can qualify with some assets, and there is a lot of Medicaid planning and VA planning that can be done that will allow you to qualify for benefits, even if you have assets. Specifically, especially in those situations where you have a spouse, right? The state does not want to make the person not living in the community penniless. Obviously, they have to live, and so there's different eligibility criteria, but there are ways to make some planning and to restructure some of your assets to qualify for these benefits, even if you don't meet the limit if you see it on the internet or someone tells you about it. All right. So what do you do if your parents or your spouse don't want to talk about this? It's really critical to talk to people before they become ill or they start to decline. Because when people become ill or they start to decline, they already feel like they're losing control of their life. They feel threatened. And then you come in with a bunch of documents and you say, oh, yeah, if you can't do this, I want you to let me do everything. That's just a red flag for that person, right? It's scary. It's scary under the best of circumstances, but if you're already feeling like you're losing control over your life and you're feeling very vulnerable, it's less likely they're going to cooperate with you to execute any documents. So I would suggest that it's something that you start early, before anybody becomes ill or has to go live in a community or whatever it may be. It's really important, the earlier the better. All right. What's the right time for permission to ask to be an agent? Right now, anybody 18 or older can execute the documents, and sometimes that can be very important even for a younger person who may be involved in an automobile accident or have some kind of a health issue where they're incapacitated. But certainly it's critical as we become older. All right. So why is it better? We covered this a little bit. Why is it better? Because, again, you want to have a plan in place, right? And the idea of the plan is to reduce your stress as the caregiver, to reduce the stress of the person who executes the documents. Because when you execute documents, then you are designating, you are choosing the person that you want to make the decisions for you, right? And that's very important. Like I had a client recently that had like 4 children, and one of whom was a doctor, but she didn't want him making healthcare decisions for her because she didn't agree with what the decisions he would make. So it gives you more control as the person executing the documents, and that's a good way to present it to someone, right? And it reduces your stress because you know who's going to handle affairs if something happens. Again, it's the sooner the better, but certainly it's better to ask before someone needs the help, right? And again, you approach someone, this is so that you can have more control over your life if you become incapacitated. You are going to designate the person or persons who will make decisions for you, and you will choose people whose decisions will align with what you want, with your values and your wishes. So, and if you don't, one of the horrors, I hate when lawyers always give horror stories, but one of the problems is if you don't have these documents and your loved one becomes incapacitated, then you're more than likely have to go to court and have a guardian appointed. And that is a legal proceeding that requires an attorney. The judge will select the person who will make the decisions for the person who needs a guardian. It's really out of that person's control. So if you have documents, you have a lot more control over who it will be, and it's also very stressful because different family members can decide they want to be the guardian, can cause some fighting among family members, and I've even had clients who think they don't need a guardian, and so they want to get in the fray. And that's very stressful for the whole family. It can really fracture a family. So I really recommend for a lot of reasons that you do the documents. All right, so what do you need? I've listed all of them up here. You may not need all of these, but I thought we would discuss these. We'll discuss them a little bit more in depth. Durable power of attorney for mental health. You need a medical power of attorney, Hipaa Release, advanced directive. There's an advanced directive for mental health. There's a declaration of guardian. Of course, our last will and testament, I think everybody's pretty familiar with that. Disposition of Remains, and a DNR. And I think most people have heard about it, Do Not Resuscitate. We'll talk a little bit about that too. So, then the question becomes, if you've waited too long, is my loved one able to sign these documents, right? So a person, to be able to sign documents, has to understand the nature of the document they're signing. They have to understand that they are designating a person to make certain types of decisions for them, whatever the document is. If someone is diagnosed with Alzheimer's or dementia, that does not automatically mean they cannot execute documents. There's no real legal standard for this like there is like for in criminal proceedings, where people can be declared incompetent to stand trial. It's really up to an attorney to determine if he or she believes the person can understand the nature of the document. So it's at the time the person signs it. So, like for example, my mom had dementia. She had times of the day when she was much better, when you could talk to her about things, and she had times of the day when you just weren't going to talk to her about things. So you can time this to be signed at a particular time of day when the person is lucid, and will be able to understand it. They don't have to be competent 24/7. Pretty much they have to be able to understand at the time they sign it the nature of the document. It's a little bit more stringent standard for a will, but for these other documents, that's the basic standard. So we have a durable power of attorney. This is the document that allows someone to make financial decisions for you, typically called a statutory durable power of attorney. The state in 2018 substantially expanded the powers that you can give to an agent. And so for younger people, typically I recommend you don't need to give the expansive power. For older people, it's probably a good idea. Essentially, you can give someone the power to manage just about all of your financial affairs. The only thing they really can't do is to change your estate plan, right? They're not going to be able to change your will, those kinds of documents. So you designate an agent to make those decisions for you, okay? And I usually recommend one agent and also a successor agent be designated, so that if something happens to the first agent, or if he's not available or she's not available, that you have at least one backup agent. Because, you know, if you sign this document and then you become incapacitated and you don't have an additional agent, you're going to be going getting a guardianship anyway, because you can't execute a new document and your agent is deceased or they're incapacitated. So it's good to go at least 2 deep, 3 deep is even better. Lots of times, if your loved one is going to go live in a community, the community will want you to have this document. They want to know who's going to be able to make financial decisions for this person. So sometimes that can be, sometimes some places, at least in the past, would not allow someone to move in unless they had a set of documents. All right. So if you have a durable power of attorney, you can designate someone to sign on your house if you sell your house, if you do a new deed on your house, on a car. Again, it's not as important on bank accounts, but if a person has a separate bank account or you're not co-owners, you want to give this document to the bank so that the agent can handle the finances of the person if they become incapacitated. All right, your medical power of attorney. Let me go back to the durable power of attorney. You have a decision on that one. You can make it effective immediately, which is the day that you sign it, or you can make it effective when you become incapacitated. Those are your 2 choices on that one. For younger people, I usually recommend when they become incapacitated. For older people, it's probably good to make it effective the date it's signed. That does not mean the person will exercise the authority on that day, but it does mean he or she will have the ability to do that if they need to. Because if you make it where they have to be declared incapacitated, that requires the involvement of doctors, healthcare providers to declare the person incompetent. Obviously, that can take some time, and I have noticed a hesitancy on some doctors' parts to declare someone incompetent unless they're really far along, for whatever reason. They can be reticent to do that. So you can be in a little bit of a pickle if you can't get a doctor to support that the person is incapacitated. All right, so we'll talk about a medical power of attorney. This is where you designate someone to make health care decisions for you. Now, there is a statute on this, as I said. So if you are the spouse of the person, you're automatically able to make those decisions. If you're not the spouse, it becomes a little bit more complicated. It basically sets out, who can make these decisions for you. This is only effective if you are unable to make health care decisions for yourself. All right, so until the time that you can't make your health care decisions, this medical power of attorney cannot be used. All right, again, this is usually required by a community, and it enables the person to order medical services, to make health care decisions for the person as to what kind of treatments, those kinds of things. All right, mental health power of attorney. This isn't really a document in Texas, but this can become critical if you have a loved one that has dementia or Alzheimer's. Over the course of the years of my practice, I don't know if you know someone with dementia, but they can become aggressive. They can actually become violent. It's part of the disease process for certain people. I know this happened with my mom. And if they become aggressive, then they can't live in the community where they're living. right? And typically what happens is they're taken to a mental health care facility. We have 2, Oceans and Georgetown Behavioral Health, for a period of at least 2 weeks. That's usually the max they'll keep them, and then they give them some kind of medication that hopefully regulates this and they can return to the community. But if you don't have this document, then no one has the power to commit that person to a mental health facility. And then you have to go through the courts. So it can be difficult. It's not something I recommend for everyone. I mean, if you have someone with some serious dementia or Alzheimer's and you're seeing some signs of, if you're concerned about that, then that's something that you should definitely consider. I know the 2 healthcare agencies do accept these mental health powers of attorney, even though it's not necessarily a Texas-sanctioned document. There's a lot of other states use them. These documents are state-specific. People ask me all the time, if I move to another state, do you have to have a new set of documents done? Probably. I don't know that they're not legally binding, but you're going to be dealing with people who aren't lawyers, so when you give them a healthcare power of attorney, they're going to want to see the form they're used to seeing in their state, right? And it can delay things, and they may not honor it because it's not on a form or doesn't contain the language that they're used to seeing. Are we not working? Okay, Hipaa release. So, believe it or not, you do not have access to even your spouse's health information. You can't talk to their health care provider, for them, their insurance company. That's just the law, it's the protections. So if your spouse goes into the hospital and you don't happen to be there, lots of times the doctors won't talk to you. Now, if you're in the room, that's considered implied consent. They will speak while you're present. And of course, if you have a family doctor or someone you've dealt with, they don't necessarily worry about any liability if they speak to you. But my mom went in the hospital and then she came out and they wouldn't even talk to my dad about what medication she was going to be on, what her prognosis was, or when her next doctor visit was. So this is an important document. It basically authorizes everyone you list on there to have access to your healthcare information or the person who's signing the document. Sometimes you will sign these when you go to a doctor's office as part of your intake packet. You might sign a Hipaa release, but this is something that you can use everywhere. You can take everywhere with you. And again, people go to hospitals where they don't necessarily have a relationship. This is certainly an important document to take to the hospital along with your medical power of attorney if that happens to you or your loved one. Also, it authorizes you to speak to the healthcare provider, the insurance company, even Medicare won't talk to you about your spouse if you don't have a HIPAA authorization or HIPAA release. Advanced Directive is your end-of-life wishes in non-emergency situations. Now, this document will only kick in if you are incapable at the time of making the decision yourself, right? This is basically to help your person designated as your agent on your healthcare power of attorney to know what your wishes are and to express them to the doctors. So there's 2 situations, one in which your doctor says to you, you have a terminal illness, and even if I give you every aggressive treatment on the planet, you're not going to live more than 6 months. The other situation is if you have some kind of a life-changing event, such as a stroke, maybe you're on life support. And the question on both of those is, do you want all aggressive treatment, or do you want to be kept comfortable and just allowed to die peacefully? So those are your choices on this. It's, like I said, it saves your agent, your healthcare power of attorney from making those decisions on his or her own. They know what your wishes are. And again, if you're competent at the time, you'll make the decision yourself, right? All right. We do have this in Texas, an advanced directive for mental health issues. So, and this is more if someone has a serious mental health issue, what kind of treatments do they want, right? Maybe they don't want a specific drug. Maybe they don't want a specific type of therapy. Because the other directive only covers physical illness, as does your healthcare power of attorney. It does not authorize you to make mental health decisions for your loved one. So this is something in the state, if someone has it, usually I recommend people go over this with their doctor and decide maybe what treatments they do or don't want if they become diagnosed. Like this is on the other advanced directive, but like for example, my husband, passed away of Lou Gehrig's disease or ALS. He did not want a respirator. He did not want certain types of feeding tubes. So those are the types of things you can express on your regular healthcare directive. On this, if there's a certain drug, if there's a certain type of therapy you don't want, you can list that as well as designating someone to make decisions for you. My clicker, I'm doing something wrong here. All right, do not resuscitate. A lot of people come to me, they've heard about this one. This is in emergency situations. This is if someone calls 911 and the EMTs come charging through your door. You show them this document. It only covers those 5 situations on there, and they will not revive the person under those 5 situations. Lawyers don't typically do this because it does require the signature of your doctor, right? Your doctor has to sign on it that you're competent to make this decision. It's a document that you would keep at your home or wherever your loved one is living that would be presented to the EMTs when they come to render any treatment. We have a declaration of guardian. As I explained to you, if you have all these documents, the chances that you're going to need a guardian are very, very slim, right? The person or persons that you've designated will be able to manage all of your financial and your healthcare affairs with the other documents. But there are occasions when maybe they won't be able to, or again, maybe your document's declared invalid, or your agent is gone and you don't have another agent appointed, when you may have to have a guardian appointed. This is a court proceeding. You go to the court, someone applies to the court to be appointed the guardian. There's 2 types of guardians. There's a guardian over the person, who can make decisions as to where the person lives, healthcare decisions. There's a guardian over the finances. They don't have to be the same person. They can be 2 different people. But the judge will make the decision as to who will be appointed the guardian. It requires an accounting with the court. There's court supervision for the guardian. It requires hiring an attorney. Now, the declaration of guardian, and remember, lawyers are kind of doom and gloomers, so that's why typically I have people do this. If there's an event where you need a guardian, you tell on this form, the judge, who you would like appointed as your guardian. And you can even exclude people on this form if there's particular people you would not want to serve as your guardian. And so typically, if you do need a guardian and this is presented to the judge, they'll follow your wishes as long as that person doesn't have something terrible in their background that would prevent them from serving as a guardian. All right. Disposition of remains. I don't do this a lot, but if you're concerned that someone is not going to follow your wishes as to whether you want to be cremated, buried, where you want to be buried, where you want your ashes scattered, you can designate a person to make those decisions for you. That's what a disposition of remains is. Typically, it's for the funeral home, and that person will be designated to make those decisions at the funeral home for you. Okay, so those are the ones, that was a death one, but the ones while you were alive are 5, right? Your statutory durable power of attorney for financial. Got your medical power of attorney for healthcare decisions. You've got your advance directive, end of life wishes and non-emergency. You have your Hipaa authorization for release of medical information, and then you have your declaration of guardian. So those are the 5 forms that would govern while you are alive. Disposition of remains and the last will and testament are documents that will govern your affairs after you've passed away. And so most people are familiar with a will. It just is an expression of where you want your property to go, who you want to receive your property upon your death. Typically it requires a probate proceeding. There's a special probate court in most counties. In Travis County we have a probate court that handles the process. Typically, you can do it by yourself, but typically it requires an attorney. And again, you want the will be determined to be valid. People will pay debts. They will gather up assets, and they will distribute to the beneficiaries as designated in the last will and testament. There are some simple ways to avoid probate if you want to do that, but even if you take steps To avoid probate, a lot of that depends on the type of assets you have. You still would like to have a last will and testament so that things don't have to go through intestate succession. Intestate succession is where someone doesn't have a will and the beneficiaries of the estate are determined by the laws of the state of Texas. Typically, if you're a younger person, it goes to your parents. If you're an older person, if your parents are deceased, it will go to your children. But the problem really becomes messy when people remarry and they have children from previous marriages. I haven't had one person that's been happy with the result in intestate succession in that situation, because the spouse who remains will share the home typically with the other spouse's kids. They don't own the house. So it's important, and especially important in that situation, that you have a will, because most people want their spouse to at least own the house upon their death, and that won't happen if it goes via intestate succession, if you don't have a will that designates that. Okay, so, all right, avoiding probate, we talked a little bit about that. That's a little bit longer conversation. It's kind of outside the scope of this, but Texas is a state, depending on the type of assets you have, where you can take some steps to avoid probate or at least minimize the assets that will pass through probate. All right, so now let's talk about, we're back to when you're alive or your loved one is alive, and you've gotten to the point where that person cannot continue to live at home. It's beyond your ability to care for them. In-home care is very expensive. I don't know if some of you have experienced that, but to have a caregiver come into the house is very expensive and outside of most people's budgets. Long-term care is expensive as well. I haven't really kept up with the cost of the care here, but it's at least $5,000 a month to live in a community and more. And that's, I don't know a lot of people that are prepared for that expense, especially if you're the spouse and you have expenses to stay in the house, and then you've got to come up with an extra $5,000 or $6,000 or $7,000 a month for your spouse to live in a community. And memory care is more expensive than that. So how are you going to pay for long-term care? All right, so you've got a couple things. Obviously, you have assets that you've saved during your lifetime, but, let's face it, most of us don't have those kinds of assets to pay for long-term care in addition to our living expenses for the other person. I know my parents were in this situation. It was a difficult situation to be in. You can have long-term care insurance. That's something that has definitely changed radically over the last 4 or 5 years. Some people have bought some policies in the 90s that pay a certain dollar amount per day for a certain number of years if they go into a certain care facility, or even sometimes if they need it at home. But typically, by the time you need to go into community, you're probably not going to qualify for long-term care insurance, or it's going to be too expensive. So if it's something that you're thinking about, you might want to do, would probably be a good idea to talk to someone about it now and see if it's within your budget. There are life insurance policies that will let you tap into them to pay some medical expenses. So I would, if that's something you're concerned about, that certainly should be something you discuss with an insurance agent as far as what kind of planning can you do to get some assistance in paying for long-term care. We have the Veterans Administration. They have a million programs, right? But there's the program that I handle is called the pension, or you may have heard of it as aid and attendance. That's a program that will give money to a married veteran, a single veteran, or a surviving spouse, a certain amount of money per month that you can use any way you wish, but typically helps defray some of the costs of living in a community. We have Medicaid that pays a huge portion of care if you are living in a skilled nursing community. We'll talk more about in these details. And then reverse mortgages. I know they were pretty sketchy years ago. I understand the government has regulated them better, but that's certainly something to explore if you're thinking about how will you pay for long-term care, because it typically enables the spouse to stay in the house, but take the equity out of the house to pay for long-term care for the spouse that needs to go into a community. And I don't know if you've talked about communities. We have independent living, right, where you go in, You don't really get much assistance. You kind of live at a community. You can get meals. It depends on the community. They prepare meals, but you're not getting assistance with any daily living tasks. Then you can go to assisted living, which means you need some assistance with tasks, and that can be ratcheted up. Now the assisted living communities will offer different levels of service, depending on how much care your loved one needs. Obviously, you know, for each level of service, you pay more. Have memory care, and then you also have skilled nursing. Skilled nursing is like what we used to think of as a nursing home. Somebody needs 24/7 care. They're not able to do anything, pretty much anything for themselves. All right, we'll talk first about, okay, personal assets. We talked about this. I mean, it's hard to save that many assets. I mean, a person, especially with Alzheimer's, could live, you know, I mean, my mom lived 10 years with dementia. You know, if you're paying $7,000, $8,000 a month for memory care, that's pretty pricey. I don't know too many people that have those kind of personal assets. So it's good to do some planning. Am I doing something wrong with this? It just doesn't want to. Oh, there. Okay. We went over long-term care insurance. Even if you purchased it a while ago, typically your premiums are not frozen, so it can get pretty expensive. I know some people have dropped it because it becomes unaffordable. Again, I would consider consulting with someone if you feel like that may be an option for you. It certainly doesn't hurt to inquire about it and find out if it's affordable and if it's an option for you or your loved one. All right, so we're going to talk about VA benefits. And again, this is just the one program. It's called Aid and Attendance. I think that's what most people know it as. The VA calls it a pension. This is for veterans who have served during a period of war. Now, you don't have to have been in the war zone. The government has determined the dates for the period of war, right? So you may think, oh gosh, you know, World War II ended in 1944. Well, the date for that goes on to 1945. So you have to have served 90 days active duty, just one day during a period of declared war. All right, there's assets limits. Rob tells me I'm learning a little bit over, so we may speed up a little bit because I want to get to Medicaid. But and you can have, there's some asset limitations, there's some income limitations, and it's a program designed to help veterans or their spouses with unusual medical expenses. So you have to the person applying has to need assistance with daily living tasks. So, I mean, it's the government, it's 5-part criteria. It can get a little confusing to figure all the eligibility criteria out. But certainly it's worth exploring. The benefits are pretty significant. You know, $2,400 to a married veteran. That's usually tax-free, and that's usually for the remainder of their life. Once you qualify, you don't have to re-qualify. Single veteran gets $2,000. Even a surviving spouse gets a little over $1,300 a month. And there is a benefit available if the veteran is healthy, but his spouse needs assistance. The benefits increase slightly every year. They track Social Security. It's about 3%. All right, Medicaid. So Medicaid is not Medicare, right? Medicare is the government health insurance. Medicaid is a program that the federal government funds, but it's specific to the state. So every state has their own Medicaid program, and there's a lot of benefits. We're just going to concentrate on the benefit that will help pay for somebody who needs to live in a skilled nursing community. You have to live in a skilled nursing community, so you need the 24/7. You can't live in assisted living, you can't live in independent living, which you can with the veterans benefit, but for this benefit, somebody has to live in a skilled nursing community. Very low income and asset limits, but again, that can be restructured. You can do some planning to qualify for Medicaid. And if you are a spouse, if you are married, you have a little bit more flexibility because, again, the state does not want the person who's not in the community to be penniless. There is a 5-year look-back period, so that prevents people from gifting away all their assets to their kids and saying, gosh, now I'm going to qualify. Any gifting has to have occurred 5 years before you apply for the benefit. And again, there's assets you can, some assets are exempt, your house, up to a certain equity amount, car is exempt, but most assets are counted, most income is counted, but you can restructure them, you can put them in sometimes trusts. There's just a lot of planning that you can do, and that's something, if you think you might want to be Medicaid eligible, and there may be something in you or your spouse's or your loved one's future, it's certainly something worth talking to an attorney about. I work with Vanessa, who's here, from Texas Medicaid Experts. We do Medicaid planning, so if you have questions about any of that, please feel free to talk to her or me about it. We're happy to answer questions about anything today. I'll stay for a little while afterwards. But just don't automatically assume you don't qualify. It's certainly worth investigating as to how you can qualify. They cover most of the cost. You will have to do a copay, the person living in the community. But again, they do allow the non-community spouse to continue, hopefully, to live in their home or wherever they're living. All right. The last thing I want to say is, if you're a caregiver, please take care of yourself, because obviously you're the most important resource that your loved one has or potentially has. So it's important to do this planning to reduce your stress, to know how to be prepared, to know what to do if a crisis occurs, because I have people contact me all the time in the middle of a crisis. They don't have the documents, they don't have a will, they can't make decisions, they don't know where they're going to put their spouse. So have a plan. Think about it. It's going to save your kids too if you can write all this down for your kids. If you can tell them about the possible benefits, where your assets are, who's going to be in charge of things if you're gone. Give them a copy of your documents. It's very, very, very important that you do this, because if you don't and a crisis happens, you're going to be so stressed out, you're not going to be able to really deal with the emotional impact of the loved one going in the hospital or passing away. It just ratchets up your stress. So I guess I'm open to any questions anybody may have about anything. Oh. Typically they should, because if you're a resident of the state of Texas, it depends on where you reside, right? And in those situations, I think there's a little more flexibility with healthcare providers. Financially, no, I would say if you're moving, and banks and everything are national and international now, so you want to just give them a copy of your statutory durable power of attorney. Every place that has a financial, somebody has a financial account, and then that's not an issue no matter where you are. But with healthcare, typically, yes, in those situations, they'll honor it.
Yes, ma'am.
Yes, you mentioned several ways to avoid probate.
Well, you can designate beneficiaries on certain accounts. You can do Ladybird deeds or transfer on death deeds on your house, and that's something, if you have a loved one that goes on to Medicaid, you definitely want to have a Ladybird deed or transfer on death deed, because if you don't, when you sell the house, obviously it won't happen if you're still in the house, but if it's a single person, the state will come in and put a lien on the house, and they will force the house to be sold to pay them back for the benefits they gave to the person on Medicaid. Now, if you have a spouse that's living in the house, that's not going to happen. But I've had lots of people come to me, they've lost their parents' house because the state came in and took it. So if you do a Ladybird deed or transfer on death deed, you avoid that. You also avoid probate. What those do is, immediately upon the death of the person who owns the property, it's transferred to the beneficiaries or the people you've designated in the deed. There's no need to go to probate, no need to take any other action.
It'd be helpful if I actually had the right microphone. I do have a quick question before we go to you. And this is one that we get asked all the time over at Age of Central Texas. How many of these documents can the person do themselves, and which ones do you really need to go through a lawyer to have done? I know the answer is have a lawyer do all of them. Because there are, you can find these things online and fill them out. But a lawyer knows so many more things that are not on that document. But in an emergency, how many of them can you just download off the internet? We've had an emergency, we've got to go to the hospital. What can I grab to save myself some headache?
Sure. Well, first of all these have to be notarized, so you'll have to have a notary available. But I'd say the most important to go to an attorney is a statutory durable power of attorney. That's the one for financial decisions, because there are a lot of decisions that can be made on that, a lot of powers. And if you don't designate certain powers, you can't do Medicaid planning. You can't do VA planning, because you have to authorize your agent to be able to gift assets to themselves or to others to be able to do the planning to qualify for Medicaid or VA. If you want to do a Ladybird deed for the person and you don't have the correct statutory power of attorney, you're not going to be able to do it. So I'd say that's the most critical. Declaration of guardian I really wouldn't even worry about unless you go to an attorney, but the other ones I think are okay. The advance directive, the medical power of attorney, your Hipaa authorization. Just be sure you get, Hipaa's federal, but just be sure you get the Texas forms. They're not as important. But again, designate an agent and a successor agent. Be sure you fill it out properly. I have people come to me and they signed in the wrong place, or the notary notarized the wrong signature. So you have to be careful about those things.
That was my question.
Okay. So it's kind of a misnomer. What is a Ladybird deed? Okay, it's a misnomer. Supposedly the myth is that, President Johnson did one of these or had one of these done with his wife. That's why they call it a Ladybird deed. But that's just a slang for it. If you see your deed, it's not called that. But it transfers ownership from the property immediately upon the death of the person who owns the property to the persons designated in the deed. All right, so nothing else has to happen. There's also a transfer on death deed that this legislature started in 2018, and there's differences between those two too, some significant differences. So, people, you can download transfer on death deed, but I don't do them a lot because for 2 years afterwards, you may not be able to, one, sell the house, and two, creditors can call that house back into the estate if they're debt owed. That doesn't happen with a Ladybird deed. So I don't do transfer on death deed a lot for those particular reasons. It's a non-warranty deed as well, and that can cause you problems with title companies. But lots of times title companies won't let you transfer the property for 2 years because they're afraid creditors might come in those intervening 2 years. Yes?
So that was my question. Would you start with the title company to a Ladybird deed or go to?
Yeah, no, so who would prepare a Ladybird deed? Title companies typically don't prepare deeds unless you're doing a transaction through them. So it's something that you would want to talk to an attorney about as part of your estate plan. I mean, you may not need it. You don't necessarily need a Ladybird deed or a transfer on death deed. A lot of it depends on what your needs are, what goals you want to accomplish. I think that's where a lawyer comes in. They help. Like, I have people come to me all the time, I need a trust. I'm like, no, probably not. It's expensive, and I think you can accomplish your goals in a much less expensive and a much simpler fashion. There are people that need trusts, but again, that's something that people download them off the internet, and they think they need them, and then they don't manage them right, and they don't put the assets in them, and then it's just kind of a waste of time.
On the Ladybird deed, is there another name for that? If I want to talk to a lawyer and...
Well, they'll probably know what a Ladybird is, but it's enhanced life estate deed.
Enhanced life. And the other question I had was, if you never qualify for Medicaid, and you were talking about planning, is there a way to plan so that if you suddenly become severely disabled and that you can convert assets some kind of way? Not so much assets as financial. Well, I guess that's an asset too.
To qualify for Medicaid, you would probably, if you haven't done any planning, you'll probably have to exhaust your assets, but there's a medical piece to it. Vanessa can talk to you a little bit more about that if you want some specifics on that.
Medicaid is a whole nother world and a whole nother animal. And I'll come to you.
I learned something very recently that I've never heard before or since mentioned, but that there is such a thing as a Christian power of attorney form to fill out. And I don't know how to go.
I don't think that's illegal. I don't think that's not a state legal document that I'm aware of. I mean, there's a statutory durable power of attorney. So what happens is the legislature comes in and they pass laws that say these are the documents that will be valid in the state of Texas. I'm not aware of a Christian durable power of attorney being valid, being sanctioned by the legislature. That doesn't mean somebody wouldn't honor it. But so that's what these documents are about. The legislature says this is the document that will be honored and valid in Texas, and this is the language that it must contain. So I'm not familiar with that one. I don't think that's a legislature-sanctioned document. But again, that doesn't mean you can't do one and it won't be honored.
Hello. My mother wasn't able to pay, I believe it was Part B of Medicare. And so a friend told her she could apply for Medicaid, the state, and the state would pay that. Well, she did. She signed it. Guess what? Medicaid now, the state now is able to take away her house. Is that true? There's a tiny little thing written on the document that I read that says after she dies, the house belongs to the state. Is that correct?
Yes, but you still have time to do a Ladybird deed if she's not deceased yet. A
You can-
Ladybird deed or a transfer on death deed.
Yeah.
If she's not deceased, you can do that. That doesn't take effect until she passes away. And when she passes away, she doesn't own the house because it's transferred pursuant to Ladybird deed or transfer on death deed, you're okay. Vanessa wants to say something. Do you want to come up here for a minute, Vanessa?
Good afternoon, everyone. So to answer your question, with Medicaid policies, there's a form that you can sign when you do the application, and you can still submit it now. It's called an intent to return home. So as long as you sign that form and there's an intent for the client to go home, then the state cannot go after the home. If there's a spouse that lives in that home, the home is also protected. The Ladybird deed or the general warranty deed comes into place as an additional protection for the home after the person passes away. But there is a form, and I can talk to you about it later, that helps protect her as well. Okay.
Yes.
I've been taking notes as you've been talking, and I wondered if I can get some copies of those screens that you're showing up here. I'm in conference now with my elder attorney, 98 years old. The end is close. And I'm facing all that what you're talking about right now.
Okay. Yeah,
if I can get copies of that.
Sure, yeah. I think, Rob, are you going to do that?
Yes, we're going to provide copies of all of the PowerPoints for all of the presentations. We'll email those to you. We are also recording the presentations, and we're going to post them on YouTube. It'll take me a few days to get that done, but we will send you the links to all of those so you'll have all of this to review, and you can share it with friends and family as well. So we'll get you taken care of.
Yeah, that's why I kind of broke the golden rule with PowerPoints. I put a lot more information on a slide than you normally would so that you will have that available if you need it. But finding an elder law attorney, typically they'll put that on their website, the State Bar of Texas. You can search attorneys by specialty. There's a National Association of Elder Law Attorneys called NALA, an acronym. You can find elder law attorneys on there. Not every elder law attorney is a member of that organization, but you might want to start with the State Bar of Texas. You can go to their search attorney, and you can put in an area of specialty, and it pull people up.
Okay. Firstly, thank you for a very impressive presentation.
Oh, I'm glad you enjoyed it.
Thank you for breaking all those legal documents out separately, because I know that some of them can be combined in certain circumstances,
Yes.
but they all have a specific purpose. About 90% of them mention an agent. I am in a very specific category of senior. I have one adult child who will not be available to be an agent. Where do I find an agent?
Typically, an attorney can help with that. I have there's some, for healthcare powers of attorney, there's some social workers in Austin that'll do it. For durable powers of attorney, there's some private entities that will do it. And I've done that recently for several clients. If there is a way around it, it's a little challenging, but it's certainly doable. Like I said, I have 2 clients right now that we were able to find a professional trustee or a professional person to be the agent for the power of attorney, and also a social worker that has a business that will act as the healthcare power of attorney. And they can be on your Hipaa as well.
We've got time for about one more question, and I'm coming right over here.
Thank you. My question is that if you have a living trust and it was set up many, many years ago, do you need to update it? If you're not changing any of your children and you've placed hopefully all your assets into your living trust.
Typically, the idea of a revocable living trust is that you don't typically have to change them, right? Like the ones I prepare say that whatever state you move to and that you die in, that law applies. And so they're usually universal national, so typically you don't, but it is important that if you want to change a trustee or a beneficiary, or if you haven't put all your assets in there. But if you feel comfortable with all of that, I'd say you probably don't need to have anybody look at it. I mean, it wouldn't hurt to have someone look at it if you're going to do some of these other documents. I do that for people a lot. If they come to me for other things, I'll look over trusts. But I have people that have them from the 90s, and they're still good. The thing is, some people go and try to write in the margins, to change things. And I'm like, yeah, that doesn't really work. But, if you follow the rules and you've done a written amendment and you've signed it and you've got all your assets in it, that should be fine. And do have, like, for example, if you have a revocable living trust, you have to have the deed to your house. Your house has to now be owned by the trust. So you have to do a new deed. So if you move to another state and you buy a new house, it doesn't automatically go into your trust. Somebody's going to have to do a deed to transfer it from you into the trust. So it doesn't hurt to get things looked at periodically.
Got this one right here.
Okay.
Hi. You mentioned, like, I have a will, and on one of your slides it says to register it at probate court, right? To make sure that what I intend for my children or my wife to have the assets. But then I saw its caveat that says, unless contested. What does that mean?
Well, you register it in a probate court after you pass. People can contest a will. So if somebody can come in, your beneficiaries, your heirs, anybody, they have to publish a notice. And people can come in and say, I don't think that's a valid will. He revoked that will. That's not his signature. There's all kinds of grounds for objecting to a will. I mean, typically that doesn't happen, but
if it's a valid will, it's okay.
If the court determines if it's a valid will.
Okay.
Yeah, that's their decision. And you can write out a will in Texas, a holographic will, all in your own handwriting. It's still good, I think, to have it notarized. But the court, it's their job to determine if that's a valid will. If nobody objects, typically they're going to just say yes.
We are out of time, unfortunately. Virginia said that she will stay and take some questions if you've got some more specific ones. But it is right now 10 o'clock. 11 o'clock. We're going to take a 5-minute break because I think everybody could stand and stretch their legs. But let's say thank you so much to Virginia Sampson for coming and spending her time today with us and sharing her wisdom. We really appreciate it.